Hi everyone, my name is Rasmus. I'm Communications and Project Manager at Danish Chinese Business Forum, and I will be moderating this webinar today. On behalf of Danish Chamber of Commerce in Hong Kong and the Danish Chamber of Commerce in China and Danish Chinese Business Forum, I'm happy to welcome you all for this webinar, IP Protection at Online Trade Fairs. Today we have two speakers from the China IP SME Helpdesk. First, we have Jennifer Tao, Project Officer, who will introduce us to the China IP SME Helpdesk. Afterwards, Matias Zubimendi, who is an IP Business Advisor, will introduce us to the potential IP risks at online trade fairs. Matias has attended several online trade fairs as well, including Canton Fair. And although online trade fairs are great for promoting products, it is also important to be aware of the IP risks involved. If you have any questions during the presentation, please do not hesitate to type them in the chat, or afterwards you will be able to raise your hand and unmute yourself. But now I think it's time for me to hand over to Jennifer. Thank you very much. Oh, and Jennifer, I think you are muted.
Sorry. Good afternoon, everyone. Good morning, everyone. This is Jennifer from China IP SME Helpdesk. And thank you for giving this chance to give a brief introduction about our organization. China IP SME Helpdesk is a European Union funded project which is designed to help European SMEs with their intellectual property rights to mainland China, Hong Kong, Macau, and Taiwan. Our project offers a variety of services that enable EU SME to make informed decisions about the IP rights, and all these services are free of charge. We support SME with inquiry helpline or some events, and also offering business tools and solutions on the website. The inquiry helpline is for EU SME ask any IP related questions, and normally you will receive a reply with 3 working days. So just send us a question to this email address. The help desk also collaborate with Chamber of Commerce, business associations, cluster organizations, and embassies. Jointly organize some training seminars, live webinars all over China and Europe. The event may cover many different types of topics, like very basic IP training or some specific topics, just like this time. So if you're interested in organizing any events, just contact us, or you would like to know what topic it may organize, and also what's the update upcoming events, just check our website. On the website, actually you will find many different kinds of IP resource, like podcast, infographic, e-learning modules, case studies, etc. The website also contains a comprehensive library of IP guidelines, which cover all major IP topics like trademark, copyright, trade secret, and GI, etc. Here, you will see some example actually, because we also offer some industry-specific guides, like how to protect in Industry 4.0, or some details like how to record your trademark from at the customs authorities, or how to protect my IP at the trade fair, etc. That's all about us. And you are always welcome to send an inquiry to the helpline. And next, Mr. Matias Zubimendi, the speaker of today, will give us a presentation about this topic. Matias He holds a master's degree in Chinese civil and criminal law, plus a master's degree in intellectual property law. He has a really strong background in both business development and IPR protection, as well as the extensive experience in terms of the legal affair, patent, and trademark. Matias, now the floor is yours.
Thank you, Jennifer. Thank you very much. Welcome, everyone. Welcome to the presentation about how to protect your intellectual property rights in China. In the screen, you can see the content of the topics that we are going to analyze today. And we will start with a brief introduction about what intellectual property rights are in general, then make an introduction of online trade fairs, to finally discuss how to prepare yourself, how to register and protect your trademarks, design patents, copyright, invasion patents, etc., etc., etc. We also discuss what to do if during a trade fair you spot an infringer that is copying you some of your products, and what to do after the trade fair once it is over, how to obtain compensation, and how to understand and analyze the Chinese market beyond what a simple trade fair can be. But let's start with the first introduction. When we talk about intellectual property rights, what we are talking about at the end of the day, it's about a monopoly. It's the company that owns one IPR basically has a monopoly over certain type of acts, for example, to sell, to manufacture, to import, to export certain type of products. In the case of invasion patents and utility models, what is protected is the technology involved or included in the product. In the case of design patents, what is being protected is how the product looks like. With trademarks, what we are protecting is all those signs that are in the product that can be used to distinguish your product from the ones of your competitors. With copyrights, we are protecting the expression of an idea, not the idea itself, but how it was expressed by the artist. But most importantly, in the case of companies, what we are protecting as well is software or databases. With trade secrets, we are protecting all information that is not known by our competitors, but is known by us, has commercial value, and it's being kept, as the name mentioned, as a secret. So again, at the end of the day, these intellectual property rights protect different aspects of your product. And when we have the registration done, what we are going to do, or what we are going to be able to do, is to perform certain specific acts and avoid third parties to do so. Also, when we talk about intellectual property rights, especially in the case of China, we have to understand two main principles. The first one is the registration principle, which means that every intellectual property right, in order to be protected, has to be registered. This means that if you do not register your trademark, you do not register your design, you don't register your patent, you will have no protection. The only exception for the registration is the trade secrets, because trade secrets, by definition, they are not registered, but only kept as a secret. There is a second rule, which applies to the registration principle, that is called the first to file. This means that that company that is the first one to file the application of any intellectual property right will have a priority over all other registrations. That's why it's very important to start the registration as soon as possible. Because if someone else started the registration, even though the registration was done in bad faith, that person or that company will have a priority for that intellectual property right, and put us in a very difficult situation, because we will have to prove that that registration was done in bad faith, and that registration shouldn't be given. The second main principle is territoriality, which means that the registration done in one country will only grant protection within the territory of that country. This means that the registration done in China will only grant you protection in China, while the registration done in the EU will only grant you protection in the EU. We have also to clarify that in the case of China, for IP protection, we have 4 different jurisdictions. We have mainland China, we have Hong Kong, Macau, and Taiwan. If we want to have full protection within the Chinese territory, we will need to start the registration that is independent for every single one of those jurisdictions. So, combining both principles, we can say that it is important to register your intellectual property rights, to register in China, if China is going to be one of your main markets, and combined, we can say that you should not do business in China without having the registration started. And final comment, if you are planning to enter the Chinese market, get your trademark, get your design, get your patent before entering as soon as possible and within those jurisdictions that you're interested in. Online trade fairs. When I said that before doing business in China, I was not talking about simply with selling or exporting or importing to China. Any approach that you do with the Chinese market, it could be an online trade fair, it could be a regular trade fair, it could be talking to a potential client or partner, already puts your intellectual property right, especially the unregistered one, in a difficult position. You should register as soon as possible. With online trade fairs, what you will be able to do from your own country, from your own office, but with effect in the Chinese market, you will be able to offer your products, to attend conferences or give conferences, to have e-meetings. Some online trade fairs offer interactive tools and offer you the chance to show some videos. But what are the main risks about intellectual property rights? The first one is that you can be copied. If a company sees that your product has potential, but the trademark is not registered, for example, they can start the registration under their own name, maybe with the simple purpose of selling back to you once you try to enter the Chinese market, maybe to start their own business using your trademark. But also it could mean the loss of IP. Later we will see that in the case of, for example, invention patents, one of the legal requirements is novelty. This means that your technology should be new, unknown by your competitors. So if you, during the trade fair, even during an online trade fair, you disclose some information that allows experts to understand how your product works, how the innovative part of your product was done, then you may lose the novelty of your product, you may lose the chance of a patent, and you lost your IP. So the general advice for online trade fairs are always register your IP before participating, even though it seems to be online. Your company is not going to come physically to China, but the effects are going to be here in China. And if you want to be protected within the Chinese territory, you need to start the registration. We've seen cases of companies that participate in EU trade fairs, and they were still copied in China. The reason is that the Chinese market is so competitive, is so fast, that once your company starts internationalizing the products, the chances of being copied are increased. So please do the registration as soon as possible. I cannot stress it more. My second advice is to assign a team to train some people to participate in the trade fair. By train them, I mean to teach them how to analyze the competitors, how to spot potential copies, and how to react in case they spot an infringement. The way to do so is to learn how the IP disputes system will work for the particular trade fair. Each trade fair will have its own set of rules that you can, of course, check in advance and learn how to start a compliance, how to start a dispute, what documents will be required, and what information you have to collect from the infringer. So having a team that knows how to proceed in case of an infringement is going to save you a lot of time, and maybe the difference between having an effect during the trade fair or not, because normally online trade fairs, they only last few days. So if you want to see that the infringer is being, for example, expelled from the trade fair, you need to act fast. Also, another advice is to check what your competitors are doing. Check in detail, analyze them, check their products, check their websites, everything. Check and understand perfectly how the market works. Start learning how the online trade fair platform works, but also at the same time, check how the different apps and how the different Chinese environment or the website, for example, the e-commerce platforms, how do they work, especially not only during the trade fair, but also the days after the trade fair, to see if you're being spotted or not, or if you're going to be copied or not. How to prepare yourself, how to prepare your company for participating in a trade fair. First, you have to decide what you're going to show, what you're going to display. In the case of trademarks, the most common scenarios is that you're going to show your company name, your product name, if there is a logo, if there is any other sign. For example, some companies have pets or cartoons that they use during for advertise their products. That all these elements should be registered as trademarks. They may also contain other type of intellectual property rights. For example, a logo may contain copyrights. When you face the situation in which one element or one characteristic can be protected by several intellectual property rights, my advice is to combine both elements, to use both ways of protection. It's always better to have more than to have none of them. You can also, or you will also display how your products look like, how they are designed. And in this case, you will have to protect them with the design patents. You will also be disclosing features about your products. What do they do? How they perform? You will have to most likely disclose some technical information that will allow potential clients or partners to be interested in your technology. Be careful with this scenario, because if you are going to disclose information that is not known by competitors and you haven't registered as a patent, you may face the scenario that I mentioned before in my example. You may be in the situation in which you will lose the potentiality of a patent, not only in China, but worldwide, because the novelty requirement is common to every single country. Also, when you're participating in a trade fair, you will be developing copyrights. And this is a very important aspect that some companies do not take into consideration. When we protect copyright, we do not only protect fine art, because the quality is not a requirement for copyright protection. So when your company is doing advertisements, when they're taking pictures of their products, when they're doing videos, when they're doing draws that are going to be disclosed, these can be protected by copyright. With one characteristic: copyright can be registered, but at the same time, copyright, thanks to the Berne Convention, which China is part of, it is protected automatically after the final work is done. The registration is only as a method of proving, but it's not necessary, technically speaking, for having protection. So, if your company sees themselves in a situation that they do not have any registered intellectual property right, then through copyright, it may be possible to obtain or take down an infringement. Also, as we will see later, there is a very specific jurisdiction for copyright infringement that will allow you to obtain very fast and efficient results. Finally, the last intellectual property rights that shouldn't be disclosed, that your company may be displaying by mistake, are trade secrets. By trade secrets, as I mentioned before, it's all information that is kept as a secret, has value, commercial value, and is not known by your competitors, and it is being protected. So when you have this type of sensible information and you are facing, for example, the situation in which you are being requested by a company to have a meeting, most likely from a potential partner who is asking you more and more information about your company, then avoid disclosing those aspects or those knowledge that can be related with an unregistered intellectual property right. For example, the name of a new product, for example, the drawings of a new design, or the explanation about how a new technology works. Do not show them, never. There is a simple rule you can follow, that is they need to know. It means that that information should only be displayed to the people who need to know that information in order to perform their duty, to perform their job. In the case of potential partners, in those situations in which you realize that in order to obtain or to close a deal, you need to disclose this sensible information, then you can have different methods or alternatives for protecting this confidential information, which is a potential NDA or non-disclosure agreement, or other type of agreements called NNN, no disclosure, no use, no circumvention agreements, which are more complex. If you see yourself in the situation that you have to disclose this type of information, please advise yourself with a lawyer, prepare an enforceable NDA or NNN agreement, and then proceed with the meeting. It is very advisable also that the online trade fair is used as a method of starting the contact, starting negotiations, but then before disclosing any simple information, just make an arrangement to have another meeting outside the trade fair with all the proper contracts signed, with the investigation about who the other parties are done, and then disclosing this important information. Online trade fairs, as I said, normally last few days, and it's very risky to have meetings in which you will disclose this information, especially if you are not advised by an IP attorney in advance about what you're going to say exactly. Finally, I want to stress the importance of having the intellectual property rights certificates, because most of the online trade fairs dispute methods, they will require you to have, for example, the trademark certificate. This means that you need to have your trademark already registered. In those cases in which you do not have the registration finished, maybe you started it, but it hasn't been granted, most likely you won't be able to proceed or to enforce it during the trade fair. But for those that you do have, please keep a digital copy of the certificates, make them accessible to the team that you assign to the trade fair, because if there is any problem, they will need it for sure. Also, please take into consideration that if there is any other extra requirement, for example, a legalization of a certificate, this has to be prepared in advance. How to start protecting your intellectual property rights? I will just go briefly one by one to summarize the main aspects. If you want to start registering your trademark in China, there are two different methods. The first one is the CNIPA. This is going directly with the China National Intellectual Property Administration and start the registration with them. If your company is not based in China, you will necessarily need to have the assistance of a local trademark attorney. Normally, the process takes from 6 months up to a year to do the registration. It can be done, it's not a complex procedure. It can be done very, very easily. There is another alternative that is with the Madrid system. The Madrid system is an international agreement that will allow individuals and companies to start the registration on their own country and expand it to third jurisdiction. In this case, it is possible to expand it only to mainland China, not the other 3 jurisdictions, but yes, mainland China. And normally the registration process is a little bit longer because it has extra phases. You can register any sign that allows your company to distinguish your products from the competitors. The important aspect is that they should be legal. This means that they shouldn't be expressly prohibited. For example, national symbols cannot be registered as a trademark. They shouldn't be functional, because if we are talking about a functional aspect of a product, then we are talking about another intellectual property rights, most likely invention patent or utility models, not about the trademark. They should be distinctive because they should be not confused with an already registered trademark, and they should be available. This means they shouldn't be registered in the Chinese market. Take into consideration, please, that trademarks, when you register them, you have to select one class or many or several classes from the 45 classes that you have. Each class protects one type of product or service. So if you want, for example, to register a trademark for clothes, you will go to class 25. The classification of classes is following the NIS agreement in Europe and in China. However, in the case of China, there is an extra level of classification in which each class has different subclasses. These subclasses do not exist in the EU. So, if you register your trademark directly with the CNIPA, there's not going to be an issue. You will just choose as many subclasses as your company needs. And eventually, if you exceed the 10 subclasses that are included for a trademark, you will only have to pay extra fees, but it is possible to do a registration. But if you are applying through the Madrid system, you have to know that the subclassification will be done automatically by the Chinese authorities when the registration process reaches the point that enters the Chinese administration part. In this case, even though the Chinese authorities are doing their best to do a proper classification, it happened that due to a mistake or due to a lack of proper explanation about what the trademark is trying to protect, the wrong subclasses unassigned. So please be careful that if you are using the matrix system, that the subclasses that are being assigned are enough to protect your product or services. Finally, another aspect about trademark protection in China is the adaptation of your international brand using Chinese characters. Normally what it is done, it's a translation of the trademark. A translation that can be done phonetically. This means by copying how the pronunciation of the trademark is using Chinese characters, or a literal translation. If your trademark, your brand has a concept, simply doing a language translation into Chinese. Ideally, your company will be combining both elements, doing a translation of the main concepts of the main idea, trying to keep the phonetical pronunciation. The danger with the simple phonetical pronunciation is that you could end up using characters with negative meanings, and you won't want to have your brand being associated with negative aspects. From the marketing point of view, that is not desirable. So please be careful and find an expert, a native expert about this topic, about how to do a proper translation, because it can be very meaningful. In the case of design patent protection, what is protected is how your product looks like. To start the registration, sadly, there's only one way. You can only start the registration with the China IP directly. There is an international agreement, which is the Hague Agreement, but China is not part of it. So if you are not based in China, there's no other option than going with the design patent attorney and do the registration with them. There is no much mystery about the documents that will be required. The application form, you will require some pictures or drawing about your product, how it looks, and a brief explanation of the product. However, you will be required other documents normally related with identification, for example, your company certificate, or if you're an individual, your passport, that will have to be legalized. And during these days, due to the COVID pandemic, we were reported that in order to legalize some documents, the waiting time can be quite long, in some cases, in some countries, even several months. So if you are planning to start the registration, and if you have interest in start the registration as soon as possible, please consult with the Chinese embassy in your country about what is the expected waiting time for legalizing this type of documents. There are some differences between China and the EU about design patent protection, but there is one that is very significant, and I want to stress it very carefully. That is that unregistered designs in China do not receive any type of protection. In the EU, they do. The protection is much shorter than if you have your design registered. But in China, if you haven't done registration, your IP is lost. It will be accessible to anyone. There is, it is true, a grace period of time of 6 months to start the registrations once the design was shown. But it's very advisable to start the registration before attending any trade fair to avoid any potential conflict. Because if you participate, if you disclose your design, you may face a scenario in which you lost your IP in China, and you not lost, but yes, shorten your protection you will receive in the EU, because in both cases the novelty requirement is global, it's for every single country. Copyright, as I mentioned before, copyright protects the expression of an idea, not the idea itself, but how it was expressed. It has the characteristic that, thanks to the Berne Convention, the protection is automatic. Nevertheless, we always advise to do the registration because it's way more easy to prove that in a certain day you will be the author of this expression of an idea, of this final work, and it will be very simple to win a case if needed. Also, it is very likely that the online trade fair, due to their own rules, will request you to show a copyright certificate in order to enforce it during the trade fair. So, taking into consideration also that registering copyright is very, very cheap and very simple because it can be done even remotely, then we advise to do the registration. For an online trade fair, what you can register is photos, text, drawing, pictures, logo, videos, anything that can be displayed in the platform. Why to do so? Because since any type of IP can be protected and can be used as a method of taking down a potential link or a potential sale, a potential offer that another company is doing during the online trade fair. If your company, for example, do not have the trademark register, or they have it registered but it has not been granted, then copyright, which is much faster, it is an alternative. But also because in China there is a very specific jurisdiction that is called the Internet Courts that can be used to deal with online copyright infringements. It is true that many of the online trade fairs, they request you as a requirement for proceeding with judicial jurisdictions, like for example the Internet Courts, to first go through the online trade fair dispute system itself. But if they do not proceed the way we want it, there's always a chance to go with the national judicial system. And because the online trade fair is happening online, we can go to the Internet Courts. And the Internet Courts have a very specific characteristic, which is that the entire process is happening online. And you can use as a method of evidence, digital evidence. So this gives you two main advantages. The first one is that the case is going to be solved way faster than a regular court. Regular court, even if it is an IP expert court, it can take several years, while Internet courts currently are solving a case within a month. The average period of time is of 27 days. So as you can imagine, if you have to compare between a case that will take years with a case that will be solved in a month, we have a very good opinion about the efficiency of the Internet court. Second, because it's going to be very easy to obtain evidence. Since digital evidence is accepted, especially the usage of blockchain as a method of saving information and present it as evidence, then it's going to be very easy for your company to, if they spot an infringement happening online, to collect all the information without having to interact with any authority from the trade fair, and then use it as a method of evidence, and prove that there was an infringement, and prove that some company was copying your products. Invention patents and utility models, what do they protect is the technology. Again, here we have two methods of starting the registration. The first one is with the China IP, directly with the Chinese administration. Again, if your company is not based in China, they will need to have a patent attorney. But there is also, an international agreement that will allow you to expand the your patent, to start it in your own country and expand it to, again, mainland China. This agreement is called the Patent Cooperation Treaty, or PCT, will give you the advantage that you can start the application in your own country with your own patent attorney and then expand it to China. In this case, due to the language barrier, it is very advisable because it will allow you to start the application fast. Nevertheless, you have to know that eventually, once you reach the stage in which you enter the Chinese administration registration process, you will need to have the assistance of a Chinese attorney and also to present a translation of the patent claims, and this should be done by an expert. You can protect your products, you can protect procedures. In several specific cases, you will be able to protect software, but this is more an exception than a rule because it can be protected only in those processes that involve the usage of software and hardware. So it's more an exception than a rule. Again, please take into consideration that for having a patent, you have to fulfill or comply with 3 requirements. One of them, and the most important, is novelty. And it's, again, very important because if you disclose your technology without starting the patent, you may lose your IP worldwide. Some jurisdictions, it is true, do recognize a grace period of time, but patents are so complex and they take so much effort, time, and money to register that is not desirable at all to be in the situation that you are running against the clock to file a patent. Also, you may be wondering what's the difference between innovation patents and utility models, especially in China. The difference are not so much in the content because they both protect technology. They can both protect the same technology. They both share the same requirements. But the main difference it is within the registration process and the registration time. While the invention patent, when it's been registered, they do check all the legal requirements. They do not do so for the utility models. So the utility models, as you can imagine, the registration time is much faster, while invention patent takes 3 up to 6 years. Utility models only within 1 year, they're already granted, normally granted. Also, that there is a characteristic in China that the patent do not receive protection while it is being registered, which means that if you start a patent application now and it's going to be granted in 6 years, during that period of time, you will not have protection. What many companies are doing is to start a parallel registration of innovation patent and utility models. So they obtain the protection of the utility model in a year, keep going with the invention patents, and when it is granted, to discard the utility model and keep using the patent. So for trade fairs, especially online trade fairs or those that may happen relatively soon, your company may use the utility model as a method of having a certificate to enforce the intellectual property right if someone is stealing our technology. Since invention patents take so long, normally companies want to participate before in online trade fairs. Then utility models are a very efficient alternative to have protection, have a certificate, and be able to protect your IP during the trade fair. Finally, trade secrets, and this is a topic that I already mentioned. All that information that you are providing and is not being protected, any intellectual property right that still not be registered should be protected as a trade secret. So please do not disclose any confidential paper. Do not, if you're giving a speech, do not give any information that can reveal your technologies. If you have expert scientists participating, giving some sort of conference, check the content of what they're disclosing, check the PPT, check everything. If you're having meetings, be careful with what type of information you're disclosing. Again, have NDAs, have NNNs if they are needed. It is not necessary to finish the agreement within the scope of the few days of a trade fair. There's always a chance to arrange a second, third meeting later after analyzing who the potential clients, who the potential partners are, and after being advised by legal experts about what to reveal, in which terms, etc. And in the case of NDAs and NNNs, I cannot stress more that they have to be done tailor-made. This is attending your own characteristics and particularities, but also by Chinese legal experts that they will enforce these agreements in China if we reach the undesirable situation in which we have to enforce it. But what to do if during the trade fair we spot someone that is copying us? The first thing to do is to collect evidence. This is critical. If you cannot prove later that you saw an infringement and that infringement is going to be removed, then you won't be able to win. You need to prove it. And with online trade fairs, to change the information that is available online, it's way faster than in a regular trade fair. They only have to take down the link, they only have to remove the picture that is an infringement, the product, etc. So before reacting, before contacting the other company, before starting a dispute, collect evidence. Collect evidence not only for the dispute itself under the rules of the online trade fair, but also for a potential further action with the judicial system. Remember that in the case of online copyright infringement, in the case of online trade fairs, blockchain can be used as a method of digital evidence. If you need to obtain non-digital evidence, because, for example, maybe we have a hybrid trade fair which is happening online but also offline, like in China, then the usage of a notary, it is the method of obtaining evidence and proving some sort of infringement. Also, it is very important to learn to know who the infringers are, to get the the legal name of those companies more than the let's say the commercial name that they give to themselves. That's why it is important, for example, if you start a dispute, to ask the the trade fair authorities what is the legal name of that company, because there is the National Enterprise Credit Information Publicity System, which is a public database published by the Chinese government that will give information about every single company registered in China. But for doing a search, for running a search in that database, you will be required to have the legal Chinese name. That's why it's very important. During the trade fair, you can start a dispute with the complaint center. Normally, regular trade fairs, the tradition is that there is a place where you can go and start the complaint, and they will follow a procedure. In the case of online trade fair, this also normally exists in this way. I mean, in an online version where you can just submit information, submit the certificates, submit the links, and they will start the procedure itself. The process normally follows the same structure, which means that you explain that there is an infringement, you offer your certificates, you explain why there is a copy. Then the trade fair notifies the potential infringement. gives them a chance to present the defense, and finally make some decisions that could be removing, for example, the products, taking down the links, or even in the most severe cases, expelling the participant from the online trade fair. The important part is that if we cannot obtain what we wanted from the trade fair, we can go to the judicial system, to the regular courts, to obtain results. We can go to regular courts, which is not advisable. I always would advise you to go with the IP courts because they are much more expert in dealing with intellectual property right aspects, especially for cases of technology which may be more complex or normally are more complex. I would advise you to go with an IP court, but also because we are online, in case of copyright infringement, you could also go to the internet courts, as I mentioned before. Please, again, the jurisdiction are internet courts, but not, for example, trademark. So finally, some takeaway messages. Please register your intellectual property rights before attending the trade fair. Remember the first to file rule, the registration principle, and the territoriality principle. Those trademarks or IP rights you may have in Europe will not grant you protection in China. Prepare your certificate, protect your trade secrets. Assign some people, train that team, teach them how to proceed or tell them to learn how to proceed. Learn how the IP complaint procedure will be, so you know what steps to follow, what documents to prepare in advance, so your company can be very efficient and see the results during the trade fair itself. And most importantly, don't forget to collect evidence before acting, because this evidence can be useful not only for the trade fair, but also for further actions, because in further actions, you may be able to be compensated and even obtain much more important results than simply taking down a link in an online trade fair. If there is any question, please contact the China IP SME Helpdesk. We will be able to provide assistance before, during, and after the trade fair. We have a helpline that we normally reply within 3 working days. We are free, fast, and confidential. This is all from our part, so we can proceed with the Q&A.
Thank you very much, Matias, for a great presentation. We already do have one question, but I will encourage all participants to type in your question in the chat or use the raise your hand function in Zoom. But here's the first question. Isn't the obvious conclusion that if you have not already filed or registered your IP rights in China, then you should not join any online, offline trade fairs in China? The moment your company and brand name is disclosed, it is easy for anyone to check your lack of IP rights in China.
Yes, sadly, that is the case. If you have no IP registered in China, normally for companies, we are talking about trademarks because it's the most common scenario. It's not advisable to participate in an online or offline trade fair. Nowadays, it's more difficult to participate in online and offline trade fairs if you are not already based in China. But in the case of online, yes, if you haven't started the registration, I wouldn't recommend you to participate. Said that, remember the first to file. Even though if your trademark, for example, is not granted and you won't be able to enforce it during the trade fair, you may think that it's still worth it to participate because you may see business opportunities. So your company, what they can do is to start the application. So you have the priority, participate. And if someone's trying to copy your trademark, then when you assign your trademark attorney when you did assign your trademark attorney for starting the registration, you can also tell them, check if there is any further attempt to register in the same trademark. to present an opposition. The opposition is an official request to the CNIPA that the trademark that is being registered by someone else in bad faith is against your own trademark, and you oppose and you stop them to do the registration. So you may face a situation in which you say, okay, I'm not protected. It is still worth it to participate. So you start the registration, you start the protection, you participate, let's say, unprotected in the online trade fair, but you know that after the registration process, you will be protected, and because you started the protection in time, you will have the priority and you will be able to avoid third parties to efficiently copy you.
Thank you. One more question here. A potential client is asking about my product details during an online fair. In my answer, I would need to explain a part of my trade secret, which the person could technically record. How to handle this situation?
Well, if your company is already well trained in trade secret management, and there is a legal department that have well-written NDAs or NNNs, and you know that those agreements will be possible to be enforced in China, then you can simply sign with this potential client or partner one of these agreements, proceed and disclose the information, because this will keep the secret as a secret, because the NDA basically what it does is to avoid the person to disclose it, or if they do, they will have to compensate you. But if you are in the scenario in which you do not have all this preparation and someone or a client or a partner is insisting, then the best way of acting, I would say, is to postpone the meeting for after the online trade fair, to prepare yourself properly and then proceed with the meeting and disclosing information. You can always say, I cannot disclose this information because it involves confidential information. Before, I will need to prepare myself. So let's please postpone the meeting for later.
Okay, we do have one more here. Important to mention that only evidence collected and notarized by a Chinese public notary is admissible to the Chinese authorities and courts. How to do so at an online trade fair?
That is true. If you want to enforce it, if you want to collect information with a notary in a offline in China, you need a Chinese public notary. In the case of online trade fairs, you have two different options. If you want to collect, let's say, the traditional evidence, which is also with the notary, you can also do it with the Chinese public notary. If you want to collect evidence digitally, then you can use blockchain as a method of obtaining evidence. In China, there are some law firms, there are some companies that they provide this type of service. You just give them a link, they collect all the information, and they basically give it to you in a way that you can use it as evidence already. They provide this type of services, and this evidence, it is admissible by, for example, the internet courts. So this is a method to proceed. Also, you have to know that, as you may know, that it shouldn't be the issue with a Chinese online trade fair. There shouldn't be any for example, problematic with accessing the website. But if you also need to prove, for example, that your company is the owner of a certain design or the owner of a certain trademark, and the way that to prove that you were using that trademark, or the way to prove that you were using that design, is using digital evidence that you posted in Western social media, for example, on Facebook, on Instagram. You have to know that these websites are not accessible in China. And the only way to have access will be with the usage of a VPN. But the usage of VPN are illegal, and evidence obtained illegally cannot be presented as evidence. So the way to obtain this is using a notary in Hong Kong, where those websites are accessible. And this way you can collect evidence in a Western, collect evidence in a Western social media platform that you can use later in the procedure as a method of proving that you are the author of a certain copyright or you are the owner of a certain trademark, etc., etc.
Okay, thank you, Matias. The clock is now 10, so we should be ending the webinar now. And I want to thank you very much for this very important presentation and for sharing your insights with all of us. Before we leave, I just want to briefly mention our next webinar, which will take place Tuesday next week, May 11th. This webinar is the third in a series of 3 on the Sino-Danish government-to-government cooperation and the Sino-Danish Joint Work Program. And this specific webinar on Tuesday will focus on cooperation within food, agriculture, fisheries, environment, and sustainable urban planning. All there's left to say now is, once again, thank you very much, Matias, and thank you also to Jennifer for being here today, and thank you to all who participated.
It was our pleasure. Thank you very much for the invitation. Have a nice day.
You too.
Thank you.
Bye.